United Nations Convention on the Law of the Sea. Article 155. The Review Conference. 1. 15 years from the 1st of January of the year, in which the earliest commercial production commences under an approved plan of work, the Assembly shall convene a conference for the review of those provisions of this part, and the relevant annexes, which govern the system of exploration and exploitation of the resources of the area. The Review Conference shall consider in detail, in the light of the experience acquired during that period, a. whether the provisions of this part, which govern the system of exploration and exploitation of the resources of the area, have achieved their aims in all respects, including whether they have benefited mankind as a whole. b. whether, during the 15-year period, reserved areas have been exploited in an effective and balanced manner in comparison with non-reserved areas. c. whether the development and use of the area and its resources have been undertaken in such a manner as to foster healthy development of the world economy and balanced growth of international trade. d. whether monopolization of activities in the area has been prevented. e. whether the policies set forth in Articles 150 and 151 have been fulfilled, and f. whether the system has resulted in the equitable sharing of benefits derived from activities in the area, taking into particular consideration the interests and needs of the developing states. 2. The Review Conference shall ensure the maintenance of the principle of the common heritage of mankind, the international regime designed to ensure equitable exploitation of the resources of the area for the benefit of all countries, especially the developing states, and an authority to organize, conduct and control activities in the area. It shall also ensure the maintenance of the principles laid down in this part, with regard to the exclusion of claims or exercise of sovereignty over any part of the area, the rights of states, and their general conduct in relation to the area, and their participation in activities in the area in conformity with this convention, the prevention of monopolization of activities in the area, the use of the area exclusively for peaceful purposes, economic aspects of activities in the area, marine scientific research, transfer of technology, protection of the marine environment, protection of human life, rights of coastal states, the legal status of the waters superjacent to the area, and that of the airspace above those waters, and accommodation between activities in the area and other activities in the marine environment. 3. The decision-making procedure applicable at the Review Conference shall be the same as that applicable at the Third United Nations Conference on the Law of the Sea. The conference shall make every effort to reach agreement on any amendments by way of consensus, and there should be no voting on such matters until all efforts at achieving consensus have been exhausted. 4. If, 5 years after its commencement, the Review Conference has not reached agreement on the system of exploration and exploitation of the resources of the area, it may decide, during the ensuing 12 months, by a 3/4 majority of the states parties, to adopt and submit to the states parties for ratification or accession such amendments changing or modifying the system as it determines necessary and appropriate. Such amendments shall enter into force for all states parties 12 months after the deposit of instruments of ratification or accession by 3/4 of the states parties. 5. Amendments adopted by the Review Conference pursuant to this article shall not affect rights acquired under existing contracts.